Everyone, and I'm indeed grateful to Sikkim Judicial Academy for inviting me. Um, so today and tomorrow, today we are going to discuss new criminal law. Some of the known faces are here. So it's a challenging in today's time. We'll try to see what kinds of changes are there, and then the rules which have been brought in for e-Sakshya, etc. that we are going to discuss. So what we thought of, we have 3 new criminal laws. So we have 4 sessions. Each session we can have 1 criminal law we discuss. So we start with evidence or Sakshya, then followed by Nyaya Sanhita. 3rd sessions tomorrow we'll do BNSS. And the 4th session, once we complete, we look into the rules which have been brought in for e-Sakshya, etc. in tomorrow's class. So in that way, we divided the entire course for tomorrow. Please feel free to ask wherever you have confusions, you have some issues in respect of any correction of evidences or some other aspects. Please don't hesitate to ask any questions wherever you think that there is some clarity is required. We are going to discuss first on the Sakshya. Now, we know very important law. In fact, for the judges, for the prosecutors, we every day come across evidence law. For the police, we don't care that much about the evidence law. Reason being that this Sakshya or evidence law, it does not give power. Police power comes from the BNSS. So we look into BNSS. We prosecute Nyaya Sanhita because that's the section we use to prosecute someone. So IPC also we are comfortable with, we know. Sakshya we don't look at. But remember for all of us, if we have to have a successful trial, if we have an ultimate outcome should be securing convictions of the perpetrators, then it is not possible without evidence law. Evidence law will come at every single stage. Now, when we brought these 3 law, one of the common things which we comes to know that okay, we want to remove colonial hangover, we want to remove the old colonial law, brought in the new law. Large number of those colonial words, if you see in the old law, it was there in the Sakshya, Indian evidence side. So you'll find many words which was there earlier that have been removed. But then, the least amount of changes out of these 3 laws, if you see, it is there in evidence law. So out of 3 legislation, the least changes we have find in the evidence law. So we'll try in 1.5 hours time, we'll try to look into what specifically changes are there. I'll focus on the changes. But please feel free to ask from any places of the evidence law, any questions if you have, because that's a subject I'm teaching from more than 2 decades in my university. So I'm teaching CRPC and evidence, these 2 subjects consistently from last 20 years. So if you have any questions, any places, please feel free to ask. So we'll discuss about the Sakshya. So what changes it has brought over the earlier law, Indian Evidence Act. So we'll discuss what is evidence, why evidence, structure, changes. Now, yes sir.
Before you start, sir, I mean to ask you some, I wanted to hear it from some expert.
Ji.
Why are the 3 laws called criminal laws? One of this Sakshya is not a criminal law. I have been asking around, and we Indians that we have mob mentality, criminal laws. What could we do?
Okay. You rightly say this evidence law is one of the laws which apply to both civil and criminal. Now, so far reforms are concerned, I can say the CPC reform we got in consistently in many places. So, major amendment in 1999, then subsequent amendments. So, we find the reforms which are there. It's a people are.
Sir may not answer now.
Yeah. So we'll discuss on this, and I'll give some idea when you look at this law, the last section which is there, when you talk with NCL, National New Criminal Laws, the last sections of all three laws are similar. That means they apply prospectively. Legislation forget that the evidence law is applicable for both civil and criminal cases. And there are civil cases in India in many places, civil cases may go for another 30-40 years. So, by applying prospectively, what we envisage or what we can visualize that even in 2050 or 2060, for some cases on the one hand we have to carry Indian Evidence Act, other hand we have to carry Sakshya. But the cases will, evidence will be same, evidence law is applicable for all old cases. It do apply to civil cases, and when we look at the digital evidence, particularly in this law, what kind of a challenges will come, which we have not visualized now. So rigid procedure for certification is a good, for criminal cases you have forensic science laboratory, police is involved, police can manage those certificates. But in the divorce proceeding, a family member who are fighting a civil suit, and if they want to admit digital evidence, how they will manage certifications? Where is the infrastructure available to us? So all these issues will come for them. But in any case, this criminal law, what's we say new criminal law, evidence law apply in all both cases. When we talk about evidence, we normally say evidence is a usual means of proving or disproving cases. Now we are all aware about it. Those who are from the judiciary and the treaties, every time we see that in the court, it's not only evidence being admitted. There are other things also getting admitted very frequently. And that's why we say evidence is a usual means. This is not a definition. When we say usual, it's a qualification. Impliedly, it is not only evidence by which I prove the case, there are something plus by which we prove the case. Now that plus can be, we will look into what are those other things can be there to proving the cases. So when we look at this evidence law, this is the only law which will talk about what is facts in issue, what is relevant fact, if it is relevant, what facts are admissible, because there are many relevant facts which might not be admissible. There are many facts which admitted might not be relevant. That's a different thing for the purpose of corroborations, etc. than other aspects. What fact may be proved, because evidence law says some fact we don't need to prove. We'll find it specifically mentioned in two places. So what fact may be proved, what fact may not be proved, entire thing we find from the Evidences Act. The fact which need to be proved, by what quality of evidence those are going to be proved. Because when you look at the Sakshya or Indian Evidence Act, you will find the structure of this law is completely different from the structure of other legislations. The way the structure has been made in the Sakshya or Indian Evidence Act, it's a completely different from the other legislation, and there are reasons for it. If some fact is to be proved, who is going to bring them? Who is going to prove them? Burden of proof, etc. That again evidence law talk about. How we are going to prove them in the court. So entire judicial processes, the manner in which the system operates, the evidence law is going to talk about it. There are some basic rules, and particularly in court we are aware of for the police officer specifically, we must know there are some basic rule of evidence which is always we have to keep in mind while dealing with cases. The first basic rule is we say evidence law require always based evidence to be given. Now many times this based evidence can become based available evidence. So the law permits dying declarations. Now, based evidence could have been the person, the lady or persons who got injury, who is making a statement, they should come and give evidence, but now their person is not available. Person is dead. So only option is available to whom they have communicated, that persons can come and give evidence. So many times when we say best evidence, it is best available evidence that moment of time. So what is best available, that we have to come to the court. We cannot allow anything which are not best available that point of time. General rule, hearsay evidence is not admissible. Section 3 mandate, which was earlier in the old law, it was section 5. Very important sections. The first sections of the relevancy. Why it is important, we will discuss later on, because the section 3 says what evidence you can give in court of law. And it laid down A, B, these two evidence can be given in court of law. Law says, another basic principle, all fact except content of the document can be proved by oral evidence. Many times we have a hesitancies, particularly in the law enforcement agency or something, that okay, where is the evidence? Because we always try to look at the documentary evidences, etc. Evidence law is very clear. Evidence law says you can prove under the sky every fact by oral evidence, except if something is in documentary form, then the document becomes best evidence. But if the document is not there, then how you will prove? By oral evidences. So oral evidence is never is a lesser quality of evidences. That's the mandate of the law. Law says you can prove every fact by oral evidence except content of the document. That's the mandate of the law. Judicial noticeable fact need not be proved. Now that's a very important provision, and there are some drastic changes in the new law. The judicial notice, when we look at the new law, there are some significant changes, and I'll discuss that. Facts admitted need not be proved. Oral evidence must be direct. Direct is against the hearsay component. These are the basic principles which always we follow in the evidence law. Now we come to changes. As you are aware of, if you see the Indian Evidence Act structure, Indian Evidence Act divided itself into three major parts. If you see Indian Evidence Act, section 1 to section 4, Indian Evidence Act says preliminary section, it has not said part 1. Section 5 to 55 of Indian Evidence Act was part 1. 56 to 100 was part 2. 101 to 167 was part 3. So the entire Evidence Act divided itself into three parts. Sometimes I say three compartments, three departments, we can say three segregated type of purpose is there. And it is a purpose. Because this structure we will not find in any other legislation. So CRPC, so complete different structure. Nyaya Sanhita, IPC, complete different structure. Evidence law itself divided into three compartments, equal valuable compartment. What the new law does is, what we have in section 3(4) in Indian Evidence Act, section 3 was definition, section 4 was definition. Section 4 defined may presume, shall presume conclusive proof. Section 3 had a remaining definition. Sakso Adhiniyam done, they bring all definition in section 2. So section 1 is operating clause, section 2 is a definition clause. Sakso Adhiniyam says this section 1 and section 2 become part 1. So accordingly, the Indian Evidence Act, which has three parts, the new law becomes 4 parts. But for all purposes, we can leave section 1 and section 2. These are, one is a introductory sections, other is a definition clause. So still in the new law itself divided into 3 parts. So we need to understand these 3 major parts which they are in the Indian Evidence Act. Applicability we are aware of. When we look at the Indian Evidence Act, like other law also, there are some sections have been deleted. What we find the deletions, like section 3J, India definition deleted. Now we are settled, we don't have a boundary issue in that sense. 82, presumption as to documents admissible in England without proof, deleted. Then we have section 88. Presumption is to telegraphic message deleted. 113. Cessation of territory deleted. 166. Jury trial deleted. We know jury trial was abolished before this when 1973 Act came, CRPC. So it was rightly deleted. Now I said this is the law where a large number of colonial terminology was there under Indian Evidence Act. And we find all these terms are deleted and we have much clean provisions in the Saksya. So you find the language like United Kingdom, Provincial Council, London Gazette, Commonwealth, Privy Council, Queen's Printer, Her Majesty, all these sections. A large number of words were there in the Judicial Notice Provision 56. Those words are all deleted. So you will not find these colonial words in the new law. So that's all deletions. There are changes we find in the new law and we will focus only on the changes what are there in the new law. Throughout the Indian Evidence Act, wherever the word electronic record was, they have added along with electronic record, they have added the word digital. So it's not only one place, there are many places. Throughout the Indian Evidence Act, wherever the word electronic was, they added digital. Some places they use the word electronic and digital. Some places they use the word electronic or digital, depending on the applicability. But you will find the digital. Now, this addition of digital, does it make much difference? My understanding is no. Why no? Because when we look at this electronic record definitions, it was never defined in Indian Evidence Act. If you have to see the definition of electronic record, we have to go to Information Technology Act. And the way Information Technology Act has defined electronic record, it is wide enough to cover almost everything which are digital. But then why they added it? Might be today we more frequently use the word digital. So even when we buy some household goods like air fryer digital, everything digital now. So might be tomorrow some lawyer will not argue that look, it is not electronic, this is digital. That option is not there. So every place we use the word electronic as well as digital. I'll come to that definition. But there is interesting another change. In the first part, they have added the word or otherwise. It was not there. When they use the or otherwise, the idea is today a large number of documents is not created manually. There are many documents which are all auto-generated, AI generated. So police department might put some software and that software will indicate any criminal will pass through a road. The software gives signal that okay, look, this criminal is passing through that car. And the another CCTV will follow that, possible. Now what the thing is saved in the computer, all the CCTV footage, they for our purpose, for a core purpose, they document. Now, these documents who created? Automatically. When we use the word or otherwise, it can cover all those circumstances where document generated manually or it's created automatically. Then for our purpose, they are all document. So that's the two changes we find in the definition of document. Another change we find, so they have added illustrations also. These are all detailed evidences, your server log, email, something is there in computer, etc. They are all electronic evidences for that purposes. Or otherwise I said already. Now I said this digital ad does not make much difference legally. The reason being that the electronic record was defined in Information Technology Act. And see the definition of electronic record. Electronic record definition says it means data record, data generated image, sound store, receive, send, etc., etc. The first word is data. Information technology has again defined the word data. And if you see the definition of data, is talk about representations. Whatever digital representation we can see today, whether we see in our smartwatch, whether we see in devices, all are nothing but they are data. If they are data, they are electronic record. If they are electronic record, they are document. So that's why I says, whether we use the word digital or not, whatever we see digitally, they are nothing but they are data. And if they are data, they are electronic record, they are document. So it does not per se make huge differences while using the word digital, but yes, at least give clarity that tomorrow we know someone will not argue that look, it is not electronic, it is digital. So in that sense, it's better to have a clear provision, use the word both electronic and digital in all places. So that's the one change which are there. Other definition we don't require. Evidence, again we find some minor changes in the evidence definition, but these changes are important because if we correlate it with the BNSS, now under the BNSS section 530, apart from all other provisions, section 530 of BNSS says, three words they have used: all trial, inquiry or other proceedings. Trial can cover your judicial proceedings, inquiry can be covered judicial, prejudicial also, because many inquiry can be conducted during investigations also. And when we say other proceedings, it can cover all the work be done by the police. And 530 says all these processes can be conducted by audio, video, electronic means. So now when they are doing by electronic means, evidence definition says when someone physically come to the court and give evidence, oral evidence, when someone give evidence by video conferencing, also oral evidence. Second part says when someone give documentary evidence or digital, both are documentary evidence. Remember the cases like long ago when there was no amendment in CRPC. Even that time, in 2000, the Supreme Court, before 2011, in Parfulla B. Desai case, there was the first time where the Supreme Court says that the statement can be recorded by video conferencing. And the issue arises, what if the person is not physically present in the court, because the idea is that the person must be present in the court. And the Supreme Court that point of time it says that if some person's video screen is appearing, so they when they give evidence by video conferencing, it's appearing in screen, it is as good as their physical presence in the courtroom. And that was the interpretation of Professor B. Desai case. So when the Dr. Professor B. Desai case talk about video conferencing, from that stage we come to now where the law says that look, when someone gives physically in the evidence in the courtroom, they are oral evidence, or they give by video conferencing, they are also oral evidences. So in that sense, that the definition has been incorporated, and it's rightly incorporated in the evidence definitions. Now when I said in the beginning, if you remember, that we don't prove everything by evidence, because I says evidence is a usual means of proving, disproving a fact. When we say usual, that means it is not only means, there are something else also. Why I said it? The reason being, when we look at our definition of evidence, our definition of evidence is narrow. It only talks about two categories of evidence: oral, documentary. It does not talk about other things which we admit in the court, which we exhibit in the court, material evidence, other evidences. So how they go to the court, again for the judges we are all aware of, but again then for there is no changes. How they go to the court, The reason being the proof definition. Now there is no changes. The proof, disprove, not proof. The same definitions are there. What was there in the old law, in the new law also. But the proof definition, when it says a fact is said to be proved, it did not say a fact is said to be proved when after considering evidence before it. If we have to rely only on evidence, then it could have said after considering evidence before it, it means court. It used the word after considering matter before it. It did not. The idea is that the court does not receive only evidence. Court receives something else also other than evidence. There are many other things which also helps to the court for either proving or disproving or not proving a particular case. So what we call them? We normally divide this thing which we admit in the court in two categories. One is evidentiary matter, because proof definition says matter. After considering matter before it, what are these matter? One matters are evidentiary, oral documentary. The second aspects are all non-evidentiary matter. What are the non-evidentiary matter? Our real evidence, physical evidence, material evidence, or even presumption. Presumption is not an evidence. We may draw inference from evidence, but what we inference drawn, that is not evidence. In CRPC, in the old law 280, we say the judge can record demeanor of a witness. Now the number has changed. Now demeanor is not evidence. What the witness says is evidence. But why we record it? Because it may help us in relying or not relying. Demeanor may give idea that whether this witness is really trustworthy or not trustworthy. Why the law permit that the judge can record demeanor? So new law also says record the same thing. Judge can record the demeanor of a witness. The demeanor is not evidence. So it's not that we only talk about evidence. We prove the case by evidence. In the court, when a case is proved, it takes into account both evidentiary thing, non-evidentiary thing. Now non-evidentiary thing, it can be demeanor, it can be judicial notice, it can be presumption, it can be real evidence, it can be physical evidence, material evidence, whatever the name we call. So all these things helps us in proving the case in the court of law. Though there is no changes here in the law. 2.2 is just refer to the clauses. Now three parts we are talking about. Now we deal with evidence every day. So some of you, it may be just to recollect again when we discuss evidence law in your early days classes. So old law has also three parts. New law has 4 parts, but leave 1 and 2. So remaining entire act is divided into 3 components, 3 parts. What role these 3 parts play? First is 3 to 50. It's called relevancy of fact. There are some changes in the relevancy. Not enormous number of a section being changed, but some changes are there. Now 3 to 50, the fact can only be admitted if those facts are relevant. From where we'll get this mandate, I'll come back to this. We'll get this mandate from section 3. In old law, it was section 5. What is the mandate? Section 3 says what evidence you can give in court of law. It says you can give evidence which are facts in issue. You can give evidence which are relevant. What relevant? What you think relevant? What I think relevant? No. It says you can give evidence relevant which are declared relevant hereinafter. That means from section 4 onwards, 4 to 50. So it's not that whether I believe it's relevant or not, whether in my perception it is relevant or not. It is only we have to find out from section number 4 to section number 50, in one of those pockets it is relevant. So as a prosecutor, when we are placing evidences, we need to find out whether evidences is relevant in one of those sections. If it is not relevant, it will not go. For the police, when you collecting evidences, we need to keep in mind the evidence which I am collecting, whether that evidence is relevant in any of these sections. If not, then it will not go. Because it's not that what you believe relevant. Law says which hereinafter declared to be relevant. So it's not our perception of relevancy. It is the law which says 4 to 50 relevant, then only it will go, otherwise it will not go. Now suppose if it is full stop there, then as a judges we can interpret, look, these are relevant, but other things can also go. It does not make full stop, comma. And then what it says, and of no other. That means the other evidence cannot go. By making this mandate and of no other in the last part, it made the relevancy chapter exhaustive. So as an IO, as a police officer, when we collect evidences, we need to see that it is relevant in one of those sections from 4 to 50. As a prosecutor, when we are placing an evidences, they need to see from 4 to 50 they are relevant. As a judge, if the other party said no, it's not relevant, you have to decide whether the fact, if admitted, it is going to be relevant or not. But otherwise, it's no power. Remember in the old law, section 165 of Indian Evidence Act, if you remember that section, because that's the power of the judge. 165 of Evidence Act says the court can ask any questions relevant or irrelevant. That was the only sections in entire Evidence Act where they use the word irrelevant. So court can ask irrelevant questions. Law permitted. Now in the new law, 165 become 168. In 168 you don't find irrelevant word. It changed the word there. The power is there. It says court can ask questions which were things appropriate. They have not used the word irrelevant, which was written earlier in 165. Yes, sir. Okay. The whole idea was, remember the two sections of law. One was 165 of Evidence Act and other side in CRPC 311. These two sections was that many times in order to extract truth or get the real truth, we might need to walk little extra. To mark, you can ask some questions. And then there was a check. The check was, if you read the last part of 165, it says, but the judgment said shall be based on the answer to the question which was relevant. The same thing in 168 also they have used it. So even you ask unnecessary questions, etc., just to extract truth, but the idea is that many times we have to ask questions which other party cannot ask. Remember, Malimat Committee in 2003, they have submitted their report. And the Malimat Committee said that why we conduct a trial? We conduct trial to find truth. So the judge's duty, what the trial do? The trial purpose is to extract or find the truth. Now to find the truth, many times we need to ask questions. And the Malimat Committee says, look, judges has a power under 165 of Indian Evidence Act, 311 of the CRPC. So one section give powers to call anyone as a witness. Other section give powers to the judge to ask anything to the witness. Why this power is there? The power is to find the statement which are truth. So some check was there. The same check is there in the new law also. But the idea is that we must give power to the court. So the court is beyond those restrictions which are applicable for public prosecutor or applicable for other. The court is beyond their power. That restriction is not available to the judges. That's the whole idea, to give the power to the court. So section 3. Because of section 3, the relevancy chapter's value enormously increases. So as soon as we find some evidences, we need to show where it is relevant. Now we come back again in 3 parts. You are all aware of it, but just again to refresh why the evidence law itself divides separately in these 3 chapters. They could have 4th part, it could have 5 parts. Why these 3 parts? It's a purpose. The purpose was, first part only says relevancy. Second part says, if these facts are relevant, by what quality of evidence we are going to prove them. So entire second part, 51 to 103, leave initial 3 sections, 51, 52, 53, which talk about some fact you don't need to prove. And there are 2 categories, judicial notice, admitted fact. But all other fact you need to prove. When you prove all other fact, what quality? So entire section 54 to 103, they talk about only quality. Even among the quality, for oral evidence there is only two sections, 54, 55. All other sections are for documentary evidence. So for quality of evidences, even for documentary, there is an enormous number of sections talk about quality of documentary evidence by which we are going to prove the case. Then what the last part do? Because now we got what relevant, we got what's the quality. Why the last part? Then last part says who will bring it, who will be the witnesses, how the witness will be examined, what kind of power judges has. If someone is asking unnecessary questions, harassing questions, can court control? Answer is yes. So enormous power has been given to the court for controlling the proceeding which goes on in the court. So that's enormous power. From where it comes? It's all come from the last part of the evidence law. That's the structure of the evidence law. Now we come to changes which have been brought in the new law. These are the hierarchy sections. We can look at one quickly. The changes which have been brought in the first part, there are 5 places we find merger of the sections. So the Indian Evidence Act sections are clubbed together. So 20, 22, 22A clubbed together become 20. 24, 28, 29 clubbed together become 22. 25, 26, 27 clubbed together become 23. 45, 45A clubbed together become 39. And 47, 47A clubbed together become 41. So you will find in 5 places different relevancy chapters are clubbed together. Content, some minor changes are there but not major changes. In some places even no change. Let me see one by one. Now in the relevancy part, the first major part is 3 to 14. Earlier it was till 16. Because 15 onwards we find admission confession, 15 to 25. Now what changes here in this part? The first sections of relevancy is section 4. It was earlier in old law, it was section 6. We call it res gesta, part of same transaction. In Latin term, we use res gesta. We also know res gesta is considered as exceptions to hearsay rule. Because if it is part of res gesta, even hearsay evidence may be admissible. That was the principle of section 6 which was there, part of same transaction. So we don't use the word res gesta, we have used the word part of same transaction. In new law, they added only these 4 words, or a relevant fact. But by adding these 4 words, it has enormously increased the scope of section 4. It's an enormously increase over section 4. So whatever the ambit was there in the old law of section 6, the ambit of new law section 4 is far, far wider. So imagine that under section 6, when we say part of same transactions, if anything happened in part of same transactions, even if it is hearsay, it will go in evidence. Now, it was going in evidence as a hearsay evidence because if it is part of same transaction, the same transaction itself gives some guarantee of truthfulness. And so we call it res gesta, law admit that part of same transaction things. But now we are increasing this not only to facts in issue, but we also increasing it to relevant fact. The relevant fact is not only one section. It starts from 4 and goes till section 50. So if anything which is part of same transaction of relevant fact, that also will be admitting here. The idea is, I am not sure whether if it is a part of same transactions of other relevant fact, will we admit hearsay? I am doubtful because it's a very exponentially we have increased the ambit of it. Because if it is a part of same transaction facts in issue, we admit hearsay also. So, yes, sir.
Example, can you cite the example to segregate this same transaction comprising both actual issue and related?
Okay, yes, sir. I am giving the idea. So, just to explain what is the risk. Suppose I have seen one person someone is there in the home. I suddenly went there. I see X is giving poison to Y. I said, what you are doing? I rushed to his brother and said, look, your brother is giving poison. This person came, this person ran away, and he found already poison, even person died. Is in my absence, suppose I am no more available, because he rushed immediately at the scene of crime, it was all happened at the immediately, instantly, so then that person's evidence may go as a part of same transaction. If it is instantaneous reaction, so when we say part of same transaction, two words we use. It should be spontaneous reaction, it should be instantaneous reaction. So either instantaneous or spontaneous, both are the same word. It considers a part of same transactions. So even in some cases, the hearsay evidence can also go under 66 of the Indian Evidence Act because it is connected with facts in issue. Whether X has given poison to Y. It is a facts in issue. So to prove facts in issue, you admit hearsay evidence. Now the similar situations. I seen the same man is buying poison from a shop. What you are doing? Why you are buying poison? I rush to his friend, his brother, and say your brother is buying poison. Now buying poison is preparations. The preparation is relevant under section 9 of the old act, now 7 of the new act. Now I am no more available. Will that brother evidence which is hearsay in nature can go to prove that he bought poison? We are expanding it enormously. So when we accepted this hearsay under section 6, it was based on the principle of res gestae that if something is a spontaneous reaction, immediate reactions, even if it is hearsay, it can be admissible. As soon as it becomes narration of past incident, how we distinguish? If it is narration of past incident, I went back home, I told to my wife, then I went to him, your brother has bought this poison, it is narration of past incident, it is not part of same transaction, it will not go. It's a hearsay rule, it will bar by hearsay rule. But if it is instantaneous reactions, it will go as a hearsay evidence, part of same transaction. When we extend this to relevant fact, are we not creating a risk that tomorrow the law enforcement may bring many evidences, may generate evidences also, which might be doubtful about the truthfulness. So whether in the background we are opening the door for admissibility of hearsay evidence. So we need to see, because I still no court has said about it. Let me see what the reaction will be there. But the law is very clear. Law was earlier used only facts in issue. Now they use facts in issue or relevant fact. When they use the word relevant fact, ambit is enormously high. So earlier ambit was narrow. Now the ambit of section 4 is enormously wide. And there is a risk that in some times we might admit hearsay evidence for relevant fact. But in any case, section is much broader. So idea is, from the old law also, the idea was that more and more evidence should come to the court, and court ultimately check what is really to be worth reliance, what is not worth reliance. So court ultimately is the authority to decide on the reliability of the evidences. Okay, 5, no changes. Facts, relevant fact they have added in heading, but it was already there in the content. So that it was there in the content, they have added in the heading. Same way 6, facts in issue was there in the content. It was in 8 or old law. Now they have added in the heading. So practically no changes in that purpose. Admission confession chapter. Earlier it was from section 17 till 31. Now in the new act it is section 15 to 25. I said with a merger of the sections. So 20 is 22, 22A become 20. 22, which is important sections about the police it is also. There are three sections, 24, 28, 29. These three sections has clubbed together in section 22. So what we see in clause 1, first part, it is 24. Now they have added one more provision, they have added one more word. If you remember earlier section 24 of Indian Evidence Act, it used the word inducement, threat, promise. The coercion word was not there. In the Sakshodhiniyam, apart from inducement, threat, promise, they have added the word coercion. I think it's good additions. Coercion is a term which has been defined in the Contract Act, and there are large number of judgments are there in the coercion. Now many times this coercion or material of coercion used to go earlier in threat. So when you say there was threat, it may include coercion also in some circumstances. But now they have explicitly used the word coercion. So inducement, threat, coercion, promise. 24, that become proviso of 22. And it says, as soon as inducement, threat, coercion, promise withdrawn, any confession made thereafter admissible. Now, it was there earlier in section 28. Because of this section only, many times when police brought some accused for recording confessional statement to magistrate, because in 164 statement, now 183 statement, you have to certify that he is giving voluntary statement, etc. And then he was not being tortured, caused, etc. What we normally do, we send the accused for segregations. We send them for 1 day judicial custody or 2 day judicial custody. So those kinds of things we normally follow. We call it reflection of time. So as a common practice, magistrate or judges do not record statement, confessional statement immediately. They give them some reflection of time, and sometimes these reflections of times are even longer.
That's only for accused, not for the
No, not for accused, sir. Yes, yes. So it's not applied for witness also. So confession for the witness, the confession issue does not come. So it's for accused. Now what I want to say here, because all three functions are here, many times when we give reflection of time, we keep them in segregated custody. So I don't know what the practice of Sikkim is, but I can say in West Bengal, in some time, we send the person for segregation for 7 days. No, that's too long. Or 4 days. What happened in practice? When the persons, where you keep in segregations, you are segregating from the police, you will keep them in the jail. You give direction that okay, he should not be mixed with the others, etc. But practically it's not possible. What is jail for criminals? It is a university for criminals. And in the jail you have their professors. So once they mix with the other criminals, their professor will give lesson that better don't confess. If you confess, he will always be there in the jail. So many a time, when they come back after 3-4 days, though they may be agreeable to confess initially, they retract and they don't confess. So ideally, we should do reflection of time, but not that much. So I don't know what the culture is, but normally 1 day good enough.
depending on the facts of the case.
Yes.
At what point of time in our state, even the sexual assault victims are being asked to go for reflection. I was surprised to see that stop that. They are being told if they reflect and come to the That was the format being followed.
Okay. For witness, there are different reasons, sir. And I'll come to whether it's a sexual offense victim will applicable or not. But one reason is what I have found, because my area of research is on human trafficking. So my doctor's work was on sex trafficking. What happened in sex trafficking are all sexual offenses victims, and we normally suggest that when suppose a police has rescued a victims of trafficking, we normally suggest the police don't do hurry for recording of 164. The reason being that still the girl is under the influence of the traffickers. So once though 2 days, 3 days, it is a counseling of the girls in home. Will we keep the girl in the home? In the home environment, she will be counseled by the social workers or maybe some NGOs who are involved. Once 1 or 2, 3 days counselings are there, then she become brave enough to reveal. But if we record her statement only on the first day when she is rescued, there is a high probability that the girl will not reveal truth. So,
There is no restriction to record subsequently also.
there is no restriction, sir, also. But normally, sir, there is no restriction. But what happened once you record one statement, again recording second statement, it becomes challenging. To the defense lawyer will get an instrument that took her statement itself is a contradictory. The first 164 is a different.
I of the case will not share that. Based on the old produce.
But sir, defense lawyers, now you have Indian Evidence Act, earlier 162,
So some
165.
Some cases of trauma also will need to be done, but that's still not for reflection. It's not reflection.
That's true, that's true. No, victim we don't require reflection, no, definitely. I agree 100%, sir. Victim we don't require reflection. Only thing in some cases, our idea is to get the truth. Might be victim in such trauma condition that she is not able to speak at this point of time, and then sometimes they refer to counselor, counseling, and thereafter they communicate. But yes, definitely there is no requirement of any reflection of time for victim. Confession was obtained on the promise of secrecy, etc. That is, secrecy is immaterial. There is nothing called secrecy. It can be admitted. Okay, there is another interesting thing. You see, in 22, they added one section, coercion. One word. Earlier section 24 was referred to when we look at section 160, 161, 162. There they have referred to 24. So police cannot use inducement, coercion, threat as mentioned in section 24 of the Evidence Act. Now also they use the same thing. But interestingly, here they use the word forward. When we look at BNSS, they still use the word inducement, threat, promise. They miss coercion. It is basically omission. So someone who drafted, they have not correlated with the evidence law. They refer to section 22 of Indian Evidence Act, Sakshya, but they have used only 3 words. When you look at one in the new law, it is 180 and 182, 159 and 181. So in these 2 sections you will find there. Okay, 23, no changes. It is basically what was there in 25, that become clause 1. What was there in section 26 become clause 2. What was there in section 27 become proviso. Specifically for the police officer, when we look at this 27 proviso, it has used the word fact discovered. My experience shows in many places when police find this 27 evidence, now become 23, last part. In the case diary, in the relevant portion, they use the word recover or recovery. The law has not used the word recovery, law has used the word discovery. And there is a distinction between recovery and discovery. Outcome is same, you got the property. Outcome is same, it will go to the court. But the difference is, recovery implies when something you got without assistance of the accused. So you come, you search my pocket, seize from my pocket, recovery. But something which I kept hidden somewhere, you could not have found unless I cooperated with you. And because I cooperated with you, you were able to find that material. This is not recovery, this is called discovery. So ideally we should write discover and not recover, because the law used the word discover in section 27, now the 23 last part. 24, which was earlier old law, section 30. All the accused who become approver, their statements are admitted under this section 30 because their confession is used against the co-accused. Now they have added one explanation here. It was not there earlier. Now this explanation has been added keeping in mind the change brought in BNSS. What the change brought in BNSS? In BNSS now we have a new section called 356, which talk about in absentia trial. So now the first time in the CRPC, we have introduced a new concept called in absentia trial. I am not talking about the merit of it, but we have introduced in absentia trial. And for that purpose, they added this explanation, and the explanation says that when a co-accused confesses or when an approver confesses in the court, his confession will not only be used against the person who is facing trial physically, but it will also be used against the person whose trial is going on in absentia. For that is the purpose of adding this second explanations to section 24. It was a section 30 earlier, that becomes section 24.
So if we can go to the previous slide.
Yes, sir.
So you said approval, sir. Approval process of recording statement is a different, not confession. So in this one, it does not include confession to police, right? Confession given to magistrate can only be used against the police.
Okay, 24 is basically, sir, used, it's a section 30 of old law. When I use the word approver, why police make someone approver? The idea is that the same fellow will make confession before magistrate.
The process is different.
Process different, sir, we is talking about. But ultimately, whose evidence recorded in section 30? If you see the trial, almost 99% of the evidence are those who become approver. Which accused normally confesses? Only those who become approver. So in reality, section 30, if you see the category of the people who make a statement, 99.9% will be those who given some approval, or maybe some smaller cases guilty pleading, that's different thing. But in the serious cases, it is the approver who confesses. So this is section 30 says, the difference between admission and confession is, admissions can be made by third party. Confession can always be by the criminal. Subject to only exception was section 30, now 24. That if someone is jointly tried, approver is jointly tried. So one person's confession will be used against the other co-accused. So the person who confesses, that confession will not be only used against that person, but it will be also used against the other co-accused person. So in practice, approval process is a CRPC process, BLSS process. But in practice, if you see these sections, who is being confesses?
So we have so the practical just say in drugs cases.
Minor, yes.
Just say in drugs cases, sir.
In drugs cases, the accused confesses to the police that he was also a part of the that drug, whatever it is. There is no 120 be put. Some recovery is made from him. This was a confession made to the police, right? So, but in the drugs law, what is the section? I can be prosecuted for possessing drugs. So that person, there is no res gestae. There is no same transaction. So he ought to be prosecuted separately. So both the accused are being brought before the court because one of the co-accused said he is also involved. In some cases, there is no recovery from the other side also. So based on this confession, I don't think that this confession includes confession made to a police officer because it uses the word confession. He cannot be clubbed in that case.
Okay, it does not include confessions to police, but definitely because that's barred by 22 in the new act. The first section itself, 23. It barred by 23 of the new act, 25 of the old act. Because 25 is very clear language. Confession made to the police inadmissible. In cases where the co-accused confesses, so the confessions can be two options. One, either it can be under 164 CRPC or 183 BNSS, or during the trial. So accused can also become a witness. So in the old system 350, now the section number has changed. So where the accused can become witness and he can confess, both the persons are available. Even accused can confess during the trial of charge friendly. That options are available. So different options are there available to the accused to confess. The whole idea is that the confession of the accused, when we can use against the co-accused. Because in criminal cases, confession can be by your confession be used against you. Exception was 30, not 24, where one confession will be used against the co-accused, but definitely not to the police. That was barred by 24, that was barred by 25 itself. That is barred by this section also. So it's categorically barred. Only thing is, why to example I give an approval? Because the utility of approval is this only. The utility of making someone approval is only that that fellow will confess and that confession will be used against the other co-accused. Now here 26, they extraction 2, they uses only that if someone is physically doing the joint trial or someone is doing joint trial in absentia, which is a new concept under BNSS. So BNSS section 356 we will find in absentia trial processes. So it may be approved, it may not be approved.
So why I'm asking this because there is one old judgment, I don't remember the High Court, which says it includes the confession made to a police officer. Most respectfully, I disagree to that. And then, but it includes confession made to a magistrate.
Yeah, I
So in drugs cases, when the accused from whom no recovery is made, but because the co-accused said to the police that he was also in court, he has to be discharged.
I agree. In drug cases, even the standard is far higher. Like for other cases, search and seizure even illegal. Many times that when search and seizure is being used in the case. In drug cases, there are plenty of cases because the case is completely depend on the seizure. If the search seizure procedures are not complied with, the people are entitled to get acquittals, discharge from the cases because illegal evidence may not be admissible in drug cases. But yes, I agree completely with you. Confession to police definitely does not fit here. And they have not used that word also. It's not used there. Okay, that basically changes we have brought in the first part. Other relevancy sections, we don't have much changes. So I'll just skip them. For our time constraint, you are aware of these many things. Okay, expert opinion on it was 45 earlier, now 39. They have added this new word or any other field. I think rightly they have added because say 10 years down the line earlier we used to say cyber forensic expert. Now among cyber forensic expert, now we have computing expert, cloud expert, mobile forensic. So there are specializations are coming up. So when they use any other field, it can cover all new development. 41 opinion evidences. They have no changes per se. Now we come to second part, which is crucial. This section is chapter structure. Now we will come to the 52. Fact of which court shall take judicial notice. 52. Very important sections. If you see these sections, 51 is not here because 51 does not make any difference. 51 was 56, which says court, the fact where the court can take judicial notice need not be proved. That's the heading of the section 50. One in the new act and the old act was 56. And then earlier old act 57 has given a long list of the facts where court can take judicial notice. But there is a difference from the old law and new law. And very interesting difference development which is there for the judges specifically. Now if see, earlier we have one dilemma or dilemma. One kind of dilemma we had that we have India is a party to so many international treaties. So we know as a student of law that ICCPR is there, ICAC are there or some other conventions are there. As a judges we are sitting in the magistrate court, where will use it? Because we want black and white letter of a law. So we rarely say in the practice it is not become useful for this international law, but legally speaking, when the government signed an international treaty, it is binding on us, binding on India. Earlier, we don't have an option of using it. Now, when you look at this section 52, what 52 says, 52 is a mandate what fact court shall take judicial notice. And 52 says court shall take judicial notice of the following fact. For us it is. What this following fact? A. All laws enforced in the territory of India. So nobody need to prove there is a law. We take judicial notice. B. International treaty, agreement, convention with country or countries by India or decision made by India at international association or other bodies. Now if some activist judge is there who think that the ICCPR makes some sense, ICSCR makes some sense, CEDAW makes some sense, which government of India has signed and ratified, can while writing a judgment considering 52 of Saksha Adhiniyam, can we take into account those international treaty? My answer will be yes. Earlier we don't have this thing. Now we have this. Earlier we don't have an option. So in a magistrate court when we are sitting there, we say what to do with ICCPR or ICSCR. But now the judicial notice provision says that if India has signed some international treaty, some convention which is a binding impact, we shall take into account. So there is an option at least available for us that we can use this treaty in some cases where we think it is appropriate. Remember, many times, even the lower court judgment make lots of differences, create new law. Let me give you one example. Now we know the POCSO Act, we see the POCSO, there are all district level judges, there are one courts are there for POCSO. I came to know here like one court is dealing with multiple cases, including POCSO. Now the kinds of protection which came in POCSO, section 31, 32, 33, which talk about the witness protections, etc. in the trial thing. Where is the foundation? The foundation was not in POCSO. The foundation was created in a case called Sakshi versus Union of India, 2006 judgment of Supreme Court. In Sakshi, first time Supreme Court laid down all these guidelines that there should be sprint between accused and victim. The defense lawyer cannot ask questions directly. They will write the questions, give to the judge. Judge will ask those questions. So you have a victims can be along with a support persons. So victim cannot be alone. There may be requirement of support persons, break, etc. So whatever we see in POCSO, the foundation was created in Sakshi case. The day when Sakshi judgment came, within 2-3 months, there was a case in a lower court in Delhi. And a judge who is doctorate from Delhi University, the case was in respect of a sexual abuse of a boy. So judge says that the Sakshi principle I will apply because the case is similar where the girl child is sexually exploited in Sakshi. It was a case of a female girl who is being sexually exploited. Now this is a case of before the court where a boy is being sexually exploited. So judge said the case is similar, I will apply the Sakshi principle in this case. Defense lawyer definitely become annoyed. Why you will apply there? This was a separate case for a female. It is a male. He said no, nothing doing. The same kind of a case will apply there. So judge pass a detailed order to make a Sakshi case applicable even in the case of boy sexual abuse case. The defense went to the High Court and the case name is Shibawadi. Shibawadi versus State of Delhi. Delhi High Court said that look, what the judge did was correct. The principle of Sakshi will also apply in cases of male boy sexual abuse. Court went one step further in Shibawadi. Court says, who are more vulnerable? Is it only the boy who is sexually exploited or some other person? Who will be the witness? The witness will be school children. So the Delhi High Court went further and said that look, the protection is not only applicable to the victim, but the protection is also applicable to other witnesses who are similarly placed. So from one lower court order, we got completely different set of law for Delhi. So many times this happened when we refer to something, we can quote them. Now earlier our hands were tied. We rarely look at the international treaty, etc. In my view, when this section 52 uses this word, that international treaty, international agreement signed by the India, we should take judicial notice, at least some options are available to us which we can use. If you see the section 57 of Indian Evidence Act, you will not find this language. It's what shall. So now we have an opportunity where these many international legal obligations which are human rights related, at least when we use it, we are not doing wrong, we are complying with section 52. So I thought this is one of the greatest contribution. If you ask me, apart from the detailed evidence things, in the Sakshodiniyam, this is one of the greatest contributions Sakshodiniyam has done for all of us, which we can use in some circumstances. Then other things are all relating to same what we see earlier.
Sir, can I?
Yes, sir. Sir. Is the mic, yes, sir.
I think I'm audible.
Ah.
In section 52, can court rely on the books, a document, or expert testimony for these facts?
Sir, under 52 we cannot take judicial notice. Okay, let me just break this section 52, 51. There are two sections. And this issue arises earlier also. Earlier it was 56, 57. Now we have 51, 52. 51 says the fact where court takes judicial notice need not be proof. 52 says the court shall take judicial notice. Among these two sections there is a silences. What is the silence? There may be other fact which is not mentioned in 52, court may take judicial notice. These are silences. And this has been interpreted earlier in many cases. So earlier, there are occasions when court takes judicial notice of things being price or increasing. There is a terrorism in Kashmir. From where the court draws these inferences? Because of 52, 1 and 52, 56, 57. Now 51, 52. So 51 says court, where the court takes judicial notice need not be proof. 52 says court shall take judicial notice on this. If you combine reading is that what is mentioned in 52, we must take judicial notice. What is not mentioned in 52, we may take judicial notice. If it is a universal truth, if everybody knows about it. But the question if it is documentary evidence will go through the check and balances mentioned in part 2. And I said earlier that when you read this entire part 2 start with here 51 till 103. Out of these three sections are 51, 52, 53, which says facts need not be proved. Two sections are there for oral evidence, 54, 55. Then remaining sections, 56 till 103, they all talk about quality of documentary evidence. So when we talk about documentary evidence, I can't say blankly yes or no. Because the documentary evidence has to go through the check or balances which provided in section 56 till 103. But there are many yes and no are there, but in between, on which. But there is a possibility that some facts which are universal truth, which everybody knows about it, court may take judicial notice. But not exactly saying it's difficult whether blankly they can take on documents or not. Okay. Oral evidence, 54, 56 talk about the oral evidence. I have nothing to do with, I'll not discuss, you know about it. 56 to 73 talk about the documentary evidence, you can read yourself. Changes which are there, the major changes are in respect of digital evidences. We'll come back after tea break and we'll look into detailed evidence. We can finish in half an hour time and then we'll start, session 2 is on Bhartiya Nyaya Sanhita, but let me finish this part in half an hour time and then I'll go to BNS. So in any case, BNS there is not much to discuss. We know the penal provisions. So second part, the major change which the Bhartiya Sakshodiniyam has done is in respect of electronic record or digital evidences. So these are again some sections number has changed. So what was 57 become 52. Primary evidence definition you find change. Secondary evidence definition you find some changes. 65B becomes 63. One new section 61 has been added. Some places we find merger also, like section 74, 75, they club together and become 74 now. These are the changes we find in the second part or in the new at least part 3 of the Sakshodiniyam. 57 primary evidence. Now these are clause 1, clause 2, clause 3 is the old provision, so I don't need to explain it. Primary evidence means any original document produced for the inspection of court, admissible. Now 4 new explanation added in primary evidence definition. Explanation 4, 5, 6, 7. Now when we talk about electronic record being primary, we need to remember that in Indian Evidence Act, when it was amended in the year 2000, when we added this electronic record etc. there, that time we never thought of to bringing the electronic record into primary. So under the Indian Evidence Act, we have a structured system of 65A and 65B. So whole idea of old law was electronic record will be admissible as per 65A, 65B. That's a mandate. And many times the cases says, court says 65A, 65B is a complete code in itself. That kind of wording you will find in the several judgment. We will come to some of the cases. So that point of time was not thought of to bring in primary. Later on, there are cases where court started talking about primary electronic record, secondary electronic record. So in all primary and secondary concept started by the judiciary. Let me go to those cases first, then we'll come to the provisions. So like for example, first very important case on electronic record was Parliament Attack case, Nabju Sandhu. Nabju Sandhu case, there the call list was seized by the police. But that call list does not have certificate. So there was no 65B certificate of that call list. Issue arises whether that call list will be admissible in evidence even in absence of certificate. The Supreme Court says that okay, the certificate is not there, no matter, what was there in computer is a primary, the call list printout is a secondary. So even if 65B is not there, it can be admitted as per 63 and 65. So 63 we know secondary evidence definition. 65 says when secondary evidence can be admissible. So court says there in Parliament in that case that the electronic record could be admissible as per 63 and 65, which is secondary evidence concept. Court further says that electronic record, if it is primary, had it been primary, it can go admitted without a certificate as a primary evidence. But this judgment of 2005, that was the rule for quite a long time, and then in 2014 it was overruled. It was overruled by Anwar Bashir. Now in Anwar Bashir case, Supreme Court says that admissibility of secondary evidence of electronic record depend upon the satisfaction of the condition as prescribed under 65B. So court was very clear that if you want to admit electronic record which are according to court secondary, there are many cases they use the word secondary, but law has not used the word secondary. I will come to that when we discuss 63. Law has used the word primary and something else, not secondary. So it's the copy things, they can be admitted if 65B conditions are fulfilled. Then court further says, as the electronic records are subjected to or susceptible to tempering, alteration, transposition, excisions, etc., without such safeguard, whole trial based on proof of electronic record can lead to travesty of justice. So court was very clear that if you want to admit electronic record, it should be based on certificate. But we also have to remember that in old law there is no format of certificate, not such rigid procedure as we see in Bhartiya Sakshodiniyam. In Sakshodiniyam we have two forms, Form A, Form B, and very rigid format has been given there for certifications.
So this, sir,
Sir.
So I request you to apprise our police officer present here. So they have been now submitting 63 certificate, not as per the format of Bhartiya Sakshya Union.
Okay, okay.
So can court, if there is already format available in the statutory provision, a unit Sakshya Union, can they submit such certificate on and on, comprising all ingredients there, mentioned there in the Sakshya Union, that can be admissible, or they are required to comply and submit certificate as per the format given in Sakshya Union?
Okay. We will discuss this when we show the certificate. So basically, definitely, once some formats are there, ideally the format need to be complied with. There was no format earlier. That's the whole idea. When earlier 65B there is no format, then every SP, according to their whims, they make their own different format of the certificate. So even in one state, you find the different format, each district following one format. Now to overcome this, new law has given a specific format of the certificate, and ideally, legally speaking, we should comply with this format. So there is no, it might be that in that format you may leave some options open. If you are not able to get data, you can keep that blank, but we cannot change the format. Format should be that, and we will come to that format there. The issue was that the electronic record can be primary. It all started by the court, and there also in this case also court says, so court laid down that they require certificate. Last, if you read, however, if the electronic record is used, I am reading last paragraph, if the electronic record is used as primary evidence under section 62, the same is admissible in evidence without compliance with the condition specified in section 65B. So the electronic record could be primary. It all is started by judiciary. It was not started by the Indian Evidence Act. So that's my contention. So electronic record could be primary and it can go without certificate. This view was expressed by the court. Not in one case, together a series of cases where court says that a primary can go without certificate.
So that judgment was there prior to this new criminal, this Sakshya Union came into force.
Okay.
But legislature never considered inserted in the Sakshya Union.
Okay. There's a larger issue, sir, whether the judgment which was prior to this act came into existence, what will be the impact of the judgment, how can we use it? It depends. When the new law came, definitely the new law, knowing well that there is some kinds of judgments exist. In interpretation of the statutes, when we study law, one principle is know, legislature knows the law. Legislature knows the judgment also. So the idea is that when the legislature has made some law, knowing well that some judgment exists, and they bypass that, so definitely the legislature is applicable. Unless until tomorrow some court may say that this provision is not applicable. That's one thing. Second thing could be that there might be some gap where the new law is silent. To give you an example, sir, earlier 41A notice, we know the Ernest Kumar judgment make it mandatory that every case we have to give the notice. Now, what was earlier 41 and 41A CRPC, that become 35 BNSS. 35 clause, sorry, 35. Nothing have been said in 35. No. Earlier practice was under the old law after Ernest Kumar judgment that notice has to be given within 14 days time. So that part, when I give training to the police, I always suggest them that so far 14 days are concerned, you comply with 14 days of the old judgment. Well, the earlier court says notice has to be within 14 days time. There the new law is silent. So if the new law is silent, definitely judgment may have some role. So even in these cases, if some law is brought some new thing, superseding the judgment, definitely new law is applicable. But in places where the new law is silent, we can take reference from the old judgment. That could be my answer to this question. So my only showing the judgment contention is that the law electronic record can be primary. It was not propagated by the legislature. It was propagated and laid down by the judicial. And what they did in the new law basically, that propagation has been legislated in, when we defined 57. So 57, when we defined primary evidence, now they have added 4 explanations. Explanation 4, 5, 6, 7. The 4 explanations, they talk about primary electronic record or primary digital record. After Anwar Basir case, we have another case, 2018, Shafi Muhammad. Shafi Muhammad brought back to Parliament at that case. It says the certificate requirements are procedural in nature. Under Indian law, many procedural rights are waived. We waive many rights. So court says the procedural rights can be waived particularly in the circumstances if the person is not holder of the original devices. That was the view there. So that again brought back to the earlier condition that the electronic record could be admissible without certificate. But after Shafi Muhammad, the last important case of 2020 was Arjun Pandit Rao. And Arjun Pandit Rao made very clear, set aside the Shafi Muhammad and say the certificate is mandatory. Electronic record cannot be admitted without certificate. So this is the final judgment on the principles of applicability of certificate. Arjun Pandit Rao is the last final judgment in a constitutional bench which laid down categorically that we require certifications for the electronic record. Now considering all these, now we got new law. And new law, when they defined primary evidence, in primary evidence they included electronic record. Sir.
What are the implications of that Pandit Rao case in the new
New law implication is that now they have prescribed very rigid certification process. And the certificate process, I can show you why I am saying is rigid, because it will create some challenge, not for criminal cases, but it will create challenge for the civil cases. Because same law, your first questions, the law is applicable in civil cases also. And that will create challenge. How it will create challenge, I will just explain to you quickly. So, explanation 1, 2, 3 was there from the old law, 57. I don't need to explain it. Explanation 4, 5, 6, 7, 4 new explanation when electronic record is primary. 1, when electronic records are digital created, stored simultaneously, etc., they are primary. So we take photographs simultaneously, our photo is uploaded in cloud. Both are primary. We take photographs, is saved in 3-4 places, primary. We take video recording our lecture here, it's saved in C drive, it's saved in E drive. Both are primary. So whatever simultaneously or sequentially saves are there, they are primary. Explanation 5 is cumbersome. Most of the time, explanation 5 might not be applicable in criminal cases. I am explaining why. Explanation 5 says, if an electronic record is produced from proper custody. Now it has not defined the word proper custody, but we know in the old Indian Evidence Act, section 90 has used the word proper custody. When the old document of 30 years old brought from the proper custody, and the court interpreted that anything which common sense we think that it is a proper custody, for law it is also proper custody. So chartered accountant, lawyer, relatives, they are all proper custody. So if an electronic record brought from proper custody and other party has not objected to, it can admit it as primary. You see the last word, unless it is disputed. In criminal cases, invariably the accused side will dispute. No accused side will be so gracious enough that accept everything. They will dispute. When it is disputed, then clause 5 is not applicable. Clause 5 is applicable when undisputed. Why they added them? It might be that there may be some circumstances where in civil cases, parties has no issue about the photographs. Husband, wife, they have photographs of their honeymoon period. Later on they fighting. The photo where the camera they took, it might not be available now. They might copy to some laptop, from laptop to some other device, from other device to the mobile phone. Now the phone where the photos are, they are not primary. Primary are where the photo has been taken. But if the other party has no objection, it can go. Because it is coming from primary proper custody. So the clause 5, primary applicability will be civil cases. And that's the reason might be they have added it. Remember, the custody cannot make something primary. Primary is the nature. When a photos are taken, the directly where it is saved or simultaneously where it is saved, they are primary in nature. But here it is deemed to be primary. So if the other party is not objecting to coming from proper custody, it can go. And why I cited it? My impression is that we have a very rigid procedure in new law, certification. Many civil cases, private litigant might not have that capability or resources to get certificate. From where they get certificate? We don't have private forensic lab that much. And even if the labs are there, they will not offer free of cost their services. So if a husband and wife is fighting a case, and if they have to show the communication in the WhatsApp or other things as an evidence of their altercations, etc., every time they need certificate. So it will become, it's not cost effective mechanism. So even if they go to private agencies for getting certificate, so like NFSU, National Forensic Science Laboratory, or other foreign science university, they offer this facility. Or any universities or other organizations might develop a private lab who can give this certificate. But then it will not be free. The litigations become expensive. To overcome that, this clause are maybe had been added, clause 5. So if both the parties are happy, court can admit. Same way we think of, many times we admit secondary evidence when the other party has no objection. So in the same way, some inferior evidence may go if the other party has no objection. So explanation 5 might be targeted to more on the civil side of cases where party can admit it.
So this the last this sentence they have added in this explanation 5, unless it is disputed. So far the criminal case, so far my knowledge goes, that there is a provision of 330 CRPC where they can admit, deny, and if they admit it, and there is a report from expert, the court will not summon to that particular expert. Court will now admit without calling that particular witness. But so far civil matter is concerned, I think what you have now just delivered, that is correct. Civil is now concerned way to read this particular explanation 5 with 330 of BNSS.
Yeah, that 330 provision was there for the expert, etc. For the forensic lab, without their presence we can admit or through.
No, 330 of BNSS says prosecution is required to submit list of documents, and accused will get an opportunity to admit or deny. And if they admit,
then you don't require.
yes,
This was there previously also.
Yeah, it was there also.
294 was there.
Sir, true sir. The same thing you will find in the Evidence Act now. In Evidence Act 58 and New Law 53, where it says fact admitted need not be proof. If you see the Evidence Act, that provisions, in the
But room for now,
So does this dispute require a real existence of dispute or mere declaration? So let me difference when I will say I dispute. So what should I write? Because disputes, therefore it's not primary evidence, or I can go into it and decide the dispute as well.
no idea. Exactly when we say other party in writing put that they don't agree with this, in criminal cases we cannot rely on the evidences.
Because I can say it's a fake photo or something. And dispute is, I think, it's insufficient.
But in any case, electronic record, the idea is as soon as the dispute comes, clause 5 inapplicable. Now you can admit either under clause 2, 3, 4, 6, 7, if it is primary, or other alternative is 63. So that option is not ended. It is only when we are treating as a primary. So if the disputes are either primary, it will not go. Expansion 5. 6, 7 basically talking about primary, again two circumstances. 1, 6, someone taken a Facebook live. All the person who is following him or her, they save the same footage in their laptop or mobile phone. Which one is primary? All of them primary. Some live transmission is going on. Multiple people save the file in their computer. Primary. So in that case, lecture is might be many people hearing online. They save in their laptop. All are primary. That was the explanation 6 says. Explanation 7, the same file is saved in multiple places. So the OC room in police stations, they have a footage. The same footage also saved in DSP office. The same footage is also saved in SP office. All are primary according to last explanations. So same footage, if saved in multiple places, they are all primary evidence. But the facts remain. How many cases we really go with primary? We don't go with the laptop, we don't go with the mobile phone, we don't go with the device. What we do, we normally make copy of it. When we make copy of it, that is not primary. So the primary may be exceptional cases when we give primary, as court said earlier, we don't require certificate. But as soon as you make copy of it, then it's not become primary. Now many times we use the word secondary, but unfortunately, even court has used the word secondary in many circumstances. Law has not used the word secondary. I'll come to that word, what the law has used the word. So 57 is defined the primary, 58 defines secondary. They have added 3 explanations. I am confused little bit on the explanation why they added these 3. 6, 7, 8. I am not devoting time on it. 61 is a new section which says electronic record does not have a lesser value. It is as good as other documentary evidence, but then it says subject to 63. That means the 63 play an important role in reliance of electronic record if we want to give them equal weightage of other documentary evidence. Now to come to what is 63? 62 says electronic record will go as per 63. It was 65 way earlier. What 63 says? Just have a look at the provision. First, notwithstanding anything contained in this adhiniyam. So whatever said earlier, you leave. Irrespective of that, any information contained in electronic record highlighted in yellow. Here it is talking about primary. Any information contained in electronic record. So you have some primary somewhere. Now it says which is printed on paper. So that primary being got printed or stored or copied or transmitted. Where you copied optical magnetic medium or maybe in computer system or computer network devices, etc. So as soon as you copy from primary, what does that become? It says hereinafter refer to computer output. Remember here they have not used the word primary. What the word they have used? Computer output. So in my view, if a law has used certain word, it is always advisable to use that word. So for electronic record is concerned, law has used only 2 words. Either primary under 57 or computer output under 63. Had they wanted to describe electronic record as secondary, they could have incorporated in 58. They have not incorporated electronic record in 58, in secondary definition. They kept remain under 63, which was earlier 65B.
No, sir, this,
Yes, sir.
this 63,
Mike says other can use it. Yes, sir.
This 63, the 63 basically covers electronic evidence only. But we are talking, you are now drawing the attention of the participants with regard to secondary evidence. That is the general. This is a specific provision for electronic, as per my knowledge was. So therefore, they have used this computer output.
Yes, sir. So why I am saying that many times we use this computer output as secondary. So just few minutes ago you also used the word secondary. So many times judges use the word secondary. Even the High Court, Supreme Court judges. evidence law. For that purpose, even Bhartiya Sakshya, they have not used the word secondary in respect of electronic record. In respect of electronic record, they have used the word primary in 57. They use the word computer output in 63. So as soon as we copy any material, it becomes computer output. When it is computer output, then how it can be admitted? 63 has answer. 63 clause 2 says that computer output can be admissible if the condition of this section is met with. What are those conditions? First condition, it says the data which put in computer was regularly fed in the regularly course of business. Now this regularly fed, regular course of business, these words are very subjective. The regularly term, you remember the Jan Hawala case, which is Shukla, where the Supreme Court has discussed what does regularly means. So a Mercedes-Benz showroom might have one transaction in a month, while Big Bazaar may have 100 transactions every day. So the regularly means for Mercedes once in a month. For a criminal enterprise who do kidnapping business, they may do one kidnapping in a month and they will earn money. But pickpocketers do 5 crimes every day. So it depends on the nature of them, regularly kept. So if one is the data regularly fed into computer. That is the first criteria. Throughout the material part, the computer was working properly. Then it says, if the computer was not working properly, such non-working should not be such which will destroy the evidence. That means, suppose if my laptop is not working, but hard disk is safe, fair enough. But if the computer is not working, it has a virus which deleting my entire evidences, or it may tamper my content, then it does not fulfill the requirement. So one, regularly fed. Two, it was working properly. At least it was working till the time when the data was even not working, the data has not affected. Now, where this computer might be? This computer can be single computer, it can be multiple computer, it can be computer network, it can be computer resource enabled thing, means cloud. And it says from below third line, for the purpose of this section, as constituting single computer, very important clause, as constituting single computer. Why they said it? Suppose police raided a call center where there is a 15 computer, all are interconnected. Now police, when they derive computer output, they doesn't need to take from all 15 computer. From one computer they get the data of all 15 computer. So because they are getting from one computer, we need only one certificate. And that's why law here says it will constitute for our purpose, for this purpose, single computer. That means we require only one certificate. We don't require multiple certificates. If they have not said it, then we could have asked for, okay, what are the certificates for other computers? Well, might be other computer has a different IMEI number, but they are interconnected and we got the data from there. So it says is constituting a single computer. Clause 4. So if by fulfilling this requirement, if you want to admit some evidences, then what you require? You require a certificate. Certificate of what? Certificate of doing following thing. What are those following things? What those computer has, what is their IMEI number, what is the details, etc. to identify computer properly. And then computer was functional, etc. So whatever we said earlier in clause 2 and clause 3, some justifications for those in the certificate. And then says, and an expert shall be evidence. That means we require 2 certificates. One certificate for A, when a copies are being made. Second certificate, the digital evidence will go to cyber forensic expert and the cyber forensic expert will fill up form B. So now we have 2 certificates. It says and an expert shall be evidence.
No, sir.
Sir, I've got a question, sir.
Yes, ma'am.
Sir, the expert has not been defined anywhere in the PSC. So, who shall we?
Of the income tax information
IT
technology.
Act it has been described, but nowhere in the PSC.
Yeah,
So,
ma'am.
like, who will
So,
we assume is the
okay.
expert?
so far expert are concerned, if we look at the section 45 of Indian Evidence Act or 39 of BSA, we have a margin. Margin is that anyone has expertise become expert. That's what they say. Having expertise is subject. But for electronic thing, that margin is not available because 79 is there. So under the 79 of this array of the IT Act, where they categorically say those are certified under that section. So that's why you will find many police department
But they need to be notified by the central government, which has.
or state government. So many places in India now to manage these situations, we don't have a CFSL or FSL that many number. So in West Bengal we have luckily we have one CFSL, one FSSL. But even then they cannot cope up with the demand. So what the police is doing in most places, I am not aware of Sikkim. Police department, CID, they are establishing their own cyber forensics department. They are recruiting cyber forensic experts. And what they are doing, the form B being filled up by those persons who are not per se police. They are having a separate wing within the police department and they are contemplating it, they are doing it. It is just to overcome. Now tomorrow might be issue comes about their partiality or impartiality. Whether are they really impartial? Because if it is coming from CFSL, Central Forensic Science Laboratory or State Forensic Science Laboratory, we always have a trust that they are impartial. But if it is coming from within the police department, if some person is being appointed as an expert for cyber forensic and they are giving form B, we have to see how the court reacts. But that's the way most of the police department in India managing it. So we require both certificate, 1 and 2, both.
Sir, what will the experts say in this? It is
Oh.
not the facts at all.
Here they did not define expert, sir. But then,
What that's the main
That is
Okay.
the main issue, sir, that is the main issue, sir. As,
certificate and an expert certificate.
so
okay,
actually,
I'll come to certificate. Yes.
so, because I had raised this question in another forum, and as per them, they said that an electronic examiner is required to examine it can be considered as an expert. But I believe there are only a few electronic examiners so far in the country itself. So there is a you have to have more of such examiners, then only they could be able to be considered as an expert. That's what I could understand.
Okay, they are. Madam Jawala want to say.
Sir, I think again we should go to 330.
हाँ
330, at the time of admissibility of the documents only, if the expert's evidence is disputed, then only the expert is to be called. If not, then the examination of the expert, which we have been doing very regularly, is actually not required.
Okay, that's provisions. It was there earlier also, and that's what he referred to. So if it had been admitted there, but we need to consider that most circumstances other party will dispute in criminal cases. If the lawyers are intelligent enough, they will make some comment, etc., and the dispute will come. Question is how we can manage this. Second, such questions. What should be the work of the expert? There are two things we need to remember. One is, now the police department, when they registered for the manpower, to cover this manpower, now under section 79 or so of the IT Act, it is not only the individual expert, but the institutions can be declared as an expertise. So CFSA, or maybe suppose you have a national law school in Sikkim, they may start a forensic lab and their lab can be accredited under section 79. Then the lab personnel can give certificate. That can fulfill the requirement. The question is, when we take electronic record, suppose from my home, police has draw some CCTV footage. Before police came, I cut in between, changed the footage, I am expert, police copied it, police can, when they fill up the form A, they can say that this device from where they got this data, this is the hash value of data, that means that the quantity of the data are there, and this content they will write. But whether these contents are in between, there is a cut and paste, in between some manipulation, in between there is a AI generated or not. Now this expertise the person who is copying does not have. This can only be certified by the cyber forensic expert. because they can certify genuinity of this electronic record.
Every electronic has to be examined now.
Every electronic has to be examined,
So
sir.
now there's no point. This is gone. You need not look at it at all if it has not been examined by expert.
Aha. So now the law says because they added to Form A and Form B, it become mandatory, and that's why it's a very cumbersome process. It become mandatory that every electronic record has to go through this certification
So
process.
now, sir, we are being giving the search and search procedure with the graphic police. That's useless. It has not
Oh,
been
okay.
examined.
That's a complete separate point. The reason being,
But still electronic.
it's electronic record. Now, police department throughout the country, because of they have a e-Sakshya app. Under the e-Sakshya app, when they do search, they record search and seizure under 105 of the BNSS. And from the e-Sakshya app is permissible, from there only they are getting generating certificate, along with that they are submitting it. The same file is also accessible to court also in many places. In my view, I may be wrong, my personal view is that the electronic record, this 105 video recording which the police is doing, per se does not require any certification. Why I am saying it, anyone may correct me, this certification issue is in respect of evidence. When police do search, what is the evidence? Evidence is the thing which police found, material which police found. The seizure is the document of it. This video recording is a surveillance to ensure that the police has done their work rightly.
So that's not for us to see.
So that is not the evidence, sir. So yes, sir.
It's being produced with
Aha.
That's
So
not evidence.
that is not, video is not evidence. Evidence is what they collected.
That was to ensure the other side also that we have searched
Sir,
properly.
So we can say it's a procedural check that the police is discharging their duty appropriately. But the facts remain, all the police are submitting certificate. All the police are submitting certificate.
So,
Yes,
so what you mean to say, sir, is that if a recording has been done in the e-Sakshya app, then the certificate which is generated in the app itself, that will suffice and no need to get it signed by any kind of expert or anybody else.
Police is doing, ma'am,
So,
nowadays.
so that means just that certificate would suffice.
I think it's suffice because that's not
No,
evidence.
that's what's but for us as a court, we are not treating that as evidence. We will not look at it. That was
That-
a formality which was complied with.
That is a procedural check whether police has done their work properly or not. Another angle you may see, ma'am. This e-Sakshya app's entire footage is available to you on cloud. Every court has access to it. I'm not saying it's not.
But that's not tendered as evidence.
No. So I am saying, in case even need arises, what is there in the cloud is primary. What is there in the cloud is primary under 57. And the primary evidence can be admitted automatically. So the court, if tomorrow some need arises, that someone challenge it, that is not genuine, etc., this video which are there in your computer which you can see, that fulfill the all requirement of 57. But in any case, this video which the police is doing under 105, it is not evidence. Evidence is what is being collected. So when police go to cyber cafe or call center, draw something from computer. When police send me notice under 94 BNSA that you bring my mobile phone, I took the mobile phone because some communications are there which require. This is evidence. Video recording will be there, etc. Whatever will be the mobile phone, the whatever contents are there, it need to have two certificate, Form A and Form B, both required. Now what the form says, let me come to form, sir. Yeah, this is Form A. Form A you will find at the end of the Sakshya. Form A will be filled up at the time when the electronic records are extracted. Many times police department does not have that manpower, so they don't extract that time, they might seize the whole laptop and later on they do it. Ideally, in my view, that should be done in the scene also. Why they need to bring laptop or why they need to if suppose CCTV footage are there, why they need to bring NVR for the purpose of evidence? They can copy from there, they can fill up form A there, and the copy which they have made, they can make multiple copy of it. One copy will go to cyber forensic expert.
So practically speaking, most of them don't have time for doing it. They have other places also, they have other duties also.
Yeah. So now if they don't apply, it will damage the case. Because now the law is very clear and it's a rigid. Law says we require two certificates, Form A and Form B. That's necessary. So Form A will be done there. Then the copy of one CD which is there, the CD they will send to cyber forensic expert. What the cyber forensic expert will do? They will fill up Form B. Along with that, they will see whether there is a manipulations done or not, some changes has been made or not, some AI generated content is there or not. So whatever the wrong you can see in the content.
So
Now, yes sir.
Contents is in the form certificate or declaration?
Is the form certificate, sir.
No, hereby of form something is written.
But it is a form certificate only to be filled by the expert. No notary, etc. kinds of things. I don't think there's a requirement. The certificate, the form certificate. So they have to give, but they are even in certificate, we are making two statement. So it's not affirmation.
But the language is not in the form of certificate.
Some lawyer has drafted, sir. So they got the idea. Yes, ma'am.
I have a question. So what is the relevance of section 105? Because the police are recording the whole process of search and seizure, and after that, without any delay, it is being forwarded to the district magistrate, sub-division magistrate, or the judicial magistrate of the first class. And thereafter, depending on which court I think the case pertains to, it's being forwarded. Correct?
Yes.
So what is the relevance then?
Okay. The relevance comes in the respect of whenever the issue arises about the genuinity of the search and seizure, because these are procedural safeguards that the police has really done entire thing in that place. When you do recording, what happened, if you ask me what is the base provision in BNSS, it is 105. The reason being that many times the search and seizure might be done here, but the seizure list will be prepared in the police station. Now that option gone. Now entire thing has to be done at the place where the seizure is, and the law 105 categorically says from which stage to which stage videography. From the starting of a search till preparing the seizure list, handing over the seizure list to the owner. Entire process has to be covered by audio, video, electronically. So this is a procedural safeguard that it was done properly. So what the relevance is, the court may look at if there is an issue arises about the genuinity of the search and seizure or not. So earlier when some other party can say that look, the seizure list has not been prepared in the scene of seizure, it is done in the police station, you don't have anything to check it. Now you have a video which can show it that it was done there. So it will definitely increase the reliability.
But can we look at it if it's not tendered as evidence? If I just look it for my own satisfaction, I have to use it as evidence or don't use
No,
it at all?
we can look into it, sir. It's a
But as I said, if I look at it, just clear my doubt. Once I look at it, I have to write something about it. And it's not tendered as an evidence. I cannot write about it. So my view is this can be tendered as evidence if this is complex.
it can. This recording is there, but remember again when we say use the word evidence, is it really evidence of the material? It's not the evidence of the materials. So it may take into account, yes. I agree to that extent.
May I
Yes,
add something?
Yes, sir.
Number one, you seem to imply that the video evidence taken under 105 can only be used as contradiction like the 161, erstwhile 161 statement. You seem to imply that because the court can't look at 161 statement as evidence. Only it can be used for contradiction. Is that what you're trying to imply?
Not necessarily, sir. It can, in fact, in most circumstances, it can be used for corroboration.
And the second
Because
point,
it will corroborate the process says a statement of the maker. The police will say, I went there, I searched, I found this. Then the defense will say whether you have taken photographs. Yes. So this video will completely corroborate the testimony of this person. So in that case, this becomes evidence. But evidence not on material. Evidence on increasing satisfaction on the seizure which has been made. So most cases it may go for corroborations. If there is something wrong play, I cannot say that okay, in no case it will not be contradictory. There might be. If police said something in the statement that they have handed over the seizure list and the entire video shows that the thing has been generated later on. Entirely AI generated. That you can prove contradict also.
the second point, there's a lot of now confusion raised.
Yes, sir, sure, sir.
As far as, now you've divided electronic evidence into two parts. One as primary evidence and one as secondary evidence.
Such law is not used the word secondary.
You in your lecture seems to have done that. That is what everybody is understanding. But if you look at 63,
Yes, sir.
if you look at 63, where they are saying copies of the electronic evidence shall be deemed to be a document. What is a document? You go into the definition of document. A document is a primary evidence. Am I wrong?
Not necessarily.
Not a copy of a document, a document.
Copy of the documents are also document. So document can be primary, document can be secondary. Same way, when it is electronic record, what I say I just caution that the law has not used the word secondary. Law has used the word primary. So electronic record can be primary. So for our understanding is concerned, which we normally say secondary, 63 I use a different word, and the word is computer output. So instead of secondary, they have used the word computer output. So my understanding, or like what you understand as secondary of electronic record, in my view, the law used the word computer output. So ideally, we should use the word computer output, because many times when we use second word, it becomes confusing. So what we understand as a secondary electronic record, according to section 63, it says hereinafter referred to as computer output. And if it is computer output, 63 compliance is required. That means form A, form B.
So this form A and B both are compulsory?
Both are compulsory. So for my reading is goes, both are compulsory. Might be tomorrow we have a parliament attack like cases where court say, oh, nothing doing, you can admit one. But so far laws are concerned, section provision says, and certificate of expert, form B, shall be evidence. So when they use the word shall be evidence, it use both certificate. Second line says one certificate and certificate of expert.
If expert evidence is there, there is chances of now contradicting the same certificate in one case.
Maybe
If it's expert certificate, then what is the question of filing the certificate by the another party?
okay. No, sir, how you will match that the file which was seized by the police is the same file which is seen or evaluated by the expert? Unless you have both certificates. Because when the police sees it, they will write that file hash number. When expert open the file, they will also write the hash number. Now hash number both matches. It is full proof that there is a no tampering has been done in respect of that evidence from the point of seizure to the point of evaluation.
If first form A was submitted by IO of the case, you produce hash value. Then the expert hash value won't be matching.
It will match, sir. That is the beauty. If it don't match, it will create dot. If it is don't matching,
No. Same document twice hash value.
same. Hash value will always remain same. Hash value is basically something in the common sense. If I bought something 1 kg, it goes to expert, it will not become 900 grams. It will remain 1 kg. So the hash value which is there, when its expert will open, it will remain same unless there is some tempering. So if you make even single A word or B word you delete, it change. Even one single full stop will change the hash value will never match. So it is foolproof.
But for the expert to check the hash value, he requires the original electronic device.
Okay.
He can't check the hash value from the copy made in the pen drive.
Okay, sir, what the technology, I am not technological expert, but what I can say to you, the hash value, suppose an expert has copied from the computer, normally this thing is done by in followance with some software. So if you see the form, yeah, SHA1, SHA256, these are the different form scale, software scale. And when you copy through applying that form, the hash value, what is there in the computer, what is there in the copy will always remain same. When this will go to cyber forensic expert, if it is complied with the procedure, the hash value, suppose a file which is there in my computer, that hash value, if it is same software, the copy which is made in a pen drive or CD, the hash value will remain same. No.
How will the expert know what is the hash value in your original computer?
It is always same. So he will do this copy. Just imagine. Just read this with 105.
Party to what is the hash value of the original evidence?
Sir, what is?
Will a party know? Like we can see in part A, part form A, that the party needs to fill this form.
Okay.
And specify that I state that the hash values of the certain evidence is this. How will the party
Okay, I absolutely agree with you. That's why I said we have a very rigid system which the law has laid down. Because suppose in my home CCTV footage, police came to make seizure, and if they ask me to fill up form A, I cannot find hash value. I cannot find hash value. And that's why nowadays seizure require police also must have that manpower. And that's why it's not only party, the three options: own, maintain, manage, operated. In the court, when you see the cases, 99% of form will be operated. Because the person who operates that point of time to make the copy, he will fill up that form. The operator persons can be police, can be some police team cyber person, can be local cyber person, it can be anyone. But someone having some expertise by which they copy. Now just link this with 105. Under 105, when the copy is being done, it's all video surveillance are there. So when you copies from drive, in up some hard disk, some video recording shows that you done instantly, you fill up the forms there only. This gives the guarantee the copy which you have made is the original copy from there. Now this copy has value, you fix up, you write in the form. The same will go to cyber forensic expert. Cyber forensic expert will also write the hash value. Now what I say, this hash value and the cyber forensic expert hash value matches, it is foolproof what we used to prove earlier, chain of custody. Now the chain of custody practically become meaningless if the hash value matches, it is foolproof from that point of time. When the copy was evaluated, to the point when expert has evaluated, there is no tamper with. There is no change. So the system generated is foolproof. Sir, most of the time, like if you read this belongs to 105, it's a very difficult to change because 105 you are doing video recording. You have a computer. From this computer you are making copy in a hard disk. Now after hard disk you analyze with the software his hash value. You fill up the form. The same CD went to cyber forensic expert. Cyber forensic expert hash value matches. It is foolproof from that point till this point. At least there is no tampering. Because even if single word add, delete, hash value will never remain same.
Contents has to be.
Sir?
If the content changes, then
So any minor change in the content the hash value will change. That's my understanding. I may be wrong, but that's my understanding. Cyber forensic expert told me the same thing. Yes.
No, sir. There's a primary evidence like my videogram. Now, if I have altered that, and you've taken a copy, you have a certain hash value in your copy, that only the copy goes to the cyber forensic, same hash value comes.
I agree.
Nobody will be able
Okay.
to know it has been that person.
So yes, sir. What I said is,
No, in that context, sir, this is only regarding admissibility.
it is only regarding the one thing it proves that the time when the copy was made, from the time the expert has made, there is no tampering. It became admin. But reliability depends on why we have cyber forensic expert. Because whether there was a AI generated, whether there is a cut, you might have a video where in between you cut the portion according to your convenience. Now this thing cannot be found out by writing hash value. This can only be found out by the expert. And that's why the form B become more important. So form B, when they fill up, they will also write about it, that where there is no temperations, no changes, no AI generated, so no cut things being found, and that's why we require both the form.
So again, coming to 105 and this foolproof theory, considering a hypothetical situation where the 105 video shows the proper search seizure, let's say a weapon of offense being recovered from a particular place, correct? Then after that, the seizure witness who comes to the court states that the weapon of offense was not recorded. Was not recovered from that particular place. But if you look at 105, you see the same seizure witness there. It's foolproof. Certificate A and B both complied with. Because the reason I'm asking this question is because we're talking about the admissibility of section 105. So now, how do we deal with this? 105, everything is foolproof, but the seizure witnesses there's discrepancy in the evidence.
Possible because now you see so many cases coming of digital arrest. When you see the cases of digital arrest, if you look at their modus operandi, you will receive a video call, and some person is sitting in the police stations, background police photo, he has a police dress, and it looks like police station something is going on, and then he asks for money that your relative is there, if you don't give money, this fine will be there. Now AI generated tool may make these kinds of a video. That's possible. So 105 videos which apparently you are showing as a 105 might be completely AI generated. But because of e-Sakshya app, if it is created by e-Sakshya app, that itself creates some guarantee. Because they cannot do in e-Sakshya app. They can do if their 105 recordings are done separately by mobile, etc. or they create 105 because e-Sakshya app is available to you. So when you see the video recording, e-Sakshya app, because it is live recorded, live transmitted, there's a 99.9% chances are there, it has not been manipulated. So that gives some guarantee. That's why the government has made e-Sakshya act. That was not foolproof even though earlier it was only says 5 minutes, now it's a 10 minutes. Every 10 minutes you have to restart this app for recording because certain seizures many times take longer time.
After every 4 minutes.
Yes,
4 minutes. Every 4 minutes.
every 4. No, but I am told it's 10 minutes now. No.
It was 4 minutes.
Achha.
So I think here, with regard to ma'am's question, I think here is where the the certificate from the expert comes to play. In cases where the evidence is not recorded, the search and seizure is not recorded through e-Sakshya, then I think if it is recorded under section 105, I think the expert certificate comes to play here. With regard to
That's true. If you want to take evidence, or maybe later on court can send for expert opinion.
So does the e-Sakshya, the present evidence for anywhere says that we have to rely on e-Sakshya application. There are private applications also. We outrightly disbelieve it. Why should I believe this application as something?
Okay.
It's after all an application, a software, right?
This software at least because
Nowhere prescribes that I should accept.
no.
Actually, we have become so dependent on this activities which somebody talked about. It's a case study with a turning hostage.
So like that's yeah. So yes, ma'am.
A part 1, part B, there are 2 forms here, no? action, I think it will get more like doubt in the court, and it will be not so beneficial for the prosecution side, because there will be some loopholes, there will be some discrepancies in one part or another part.
Okay, that the issue is, if there is any kinds of a discrepancy between these two forms, it will decrease the reliability. But if the both are matching, if synergy is there, it make the case foolproof. So that's so in some cases what you have, all unnecessary things can be removed, but what we are getting a solid evidence to rely upon. Yes, ma'am.
So,
Yes, someone is saying that.
so can we treat whatever is recorded in e-Sakshya, can't we treat it as primary evidence because it's going to the cloud?
So I am saying that. So,
So then when it's treated as primary, then do we need all these?
okay.
Form A, B?
That's the reason the e-Sakshya apps, videos access are available with judiciary also. So in cases they want to see that, in cases if they want to see that, that is what is there in the cloud is always considered the primary under 57. So that, and then we can take judicial notice of many things. When we link the judicial notice fact, 51 and 52, I said there are many silences. What is there in 52 is always free. And then you remember, we should not forget evidence law, what was there in 114, now become 119.
So then all Indians are also in cloud.
So I think,
Slot is.
so the same principle, that even when it comes to electronic documents, the proof is beyond reasonable doubt.
And cloud is just a concept, sir. All the servers, if I'm accepting cloud, I should be able to accept it from the server which is physically present. Even cloud has a physical server, right? So by that context, I should be able to admit it as a primary evidence. All the other servers which are not in the cloud. After cloud is a server.
It's true. So, idea is, suppose.
So my point is, e-Sakshya videos and all has no special privilege in the Indian Evidence Act. It has to go through the same process which the other electronic evidences has to. That's my point.
It's a form of CPC also.
It is. Only difference what I can say is, like say suppose if my email account you want to access from the cloud, so it is there in the Gmail cloud somewhere, then I have to open it for you. Then your cloud, what is there in the cloud is a foolproof things. You can take judicial notice of it, you can take presumption under 119. Because 119 says common presumptions. We can draw any inferences which natural course of event we think as a genuine. So 119 is not elite, like is removed. We can always 119 is of our use, which was earlier 114. Under 114, many general presumptions the court has drawn. So those presumptions can be drawn. Only thing is because e-Sakshya apps are accessible to us easily, and the cloud videos we can see it. If the need arises, we can always look at it, cross-check it. So that's guarantee you don't get in the other evidence, because unless other party produced it. That is always there with the court.
But there is no provision which allows me to use.
Directly it's not, but like other evidences can also go, no, sir.
Because the law even prohibits looking into the case diary unless I really require to get it. And then use it not as a
Okay. Case diary is completely something, like there are some other restrictions also in case diary. So,
because I just can't look it up.
yes, sir.
So until and unless whatever is in the cloud of e-Sakshya, until and unless it is not reduced in a computer output and certified by these two form, part A and part B, it holds no value, no water in the court. Am I safe to say that, sir?
In my view, no. Why? What I said earlier, e-Sakshya apps we are recording 105 search and seizure. What I said earlier to you, you remember traditional search and seizure. In traditional search and seizure, we have two witnesses. The witness come and certify that it was done in my presence. The accused party says no, it was not done there. So he brings three witnesses. Those three witnesses, look, he was with me. Such was not done there. I have seen it has done in police station. So contradictions created by the accused traditional. Now suppose in e-Sakshya apps are there, other party can always say it was not in video recording. To contradictions, many evidence for public contradictions to go, evidence for public corroborations to go in the evidence, Anything which corroborate become relevant, anything which contradict become relevant under the evidence law. This is for evidence. What I said is, when a police records under 105, they record the video. Is that video is evidence, or the material which the police sees, that is evidence? It's a material. Video is a surveillance to check whether police has done their work properly. Because if they don't do the work properly, it creates doubt on the reliability of these evidences. So to decrease the reliability of the evidences, what we used to do earlier? We used to bring contradictory evidences. Some other witness will come and contradict. Not today, we can challenge that video was not recorded properly. It was not done there. It is AI generated. Another party can challenge. But then court has an option that court can log in the clock and see that the e-Sakshya app, it was simultaneously exactly the time it was recording, showing it was uploaded there or not. When it is uploaded simultaneously, it is primary. Now people can't challenge primary. People can challenge primary also. There are many primary evidence which can be challenged. If something is primary does not mean that 100% declaration. A dying declaration. It's primary. If you write something, the evidence, if it is documentary form, the original document is primary. Is it not challenged? People can challenge. Any evidence can be challenged in the law. The question is, when it is challenged, you can create contradiction. But for e-Sakshya app, because it is accessible to us, the primary file also, we can look at the primary file, and then under the evidence law, you have a general presumptions under 114, 190, Evidence Act 114, Sashodhinium 119. We can always draw inference that the police which has uploaded in e-Sakshya app is a true copy what they have done there. So I am saying this is basically to increase the reliability on the evidence. Per se, this is not evidence. Evidence is what you seized, what the material you found, what the copying you have done. The e-Sakshya app seizure is the only guarantee that the police has diligently done their work, whatever the manner they have proposed in the writing. So it creates an inspiration. It is for the purpose of increasing the reliability on the evidences. So reliability can increase for many reasons. So we cannot say blankly like we will not accept at all. It can go to the evidence, sir.
So it all depends upon the judge whether he would like to refer to the e-Sakshya video or not.
It depends upon the
It depends on the how much reliability are there in the other parties. It depends on primarily the defense lawyer how strong is enough to create the dot in the mind of the judge. If the lawyer is not good enough, they cannot create the dot in the mind of the judge.
So just to
You specifically implied that under e-Sakshya Act, certificate is not required. However, if you see, e-Sakshya generates a certificate.
Yes, sir.
So the ones who designed e-Sakshya knew that a certificate is required. Why didn't they comply with 63, this certificate? The certificate is not the same, if you look at it.
Okay. We can challenge this in the court, sir. What I say to you, hope I make my point very clear. Evidence law, police department, when they created the e-Sakshya app, they created a mechanism for getting certificate from there. So Form A certificate automatically generated. They can click the button, the certificate will automatically generate a digital science and certificate.
But it's not the same certificate.
The question is, ideally what I said is, we have to be very clear. We are insisting upon certificate A and B. We are insisting upon certificate A or B in respect of a video which is not per se evidence. Like, hope you have to clear this point. What is evidence? Evidence is what police seized. Police came to my home, I have contraband article, I have some paper, I have some diaries which contains all the wrong deed I have done. Police all seize this material, these are evidence. It can be documentary, it can be electronic.
So there's a problem here, sir. Because under the Narcotic Drugs Act, under the Sikkim Anti-Drugs Act, there's a procedure which requires to be followed. So if you follow 105 and show to the court, whatever the witness says, that video you show all stepwise that all procedures have been followed. It is evidence that the procedure has been followed. It is evidence.
So, sir, what's wrong with it, sir? So let that be got conviction. Okay, so that's the evidence I will give an answer, sir. Yes, yes.
So very ground reality, what is happening is ground reality. Like when I was in Gangtok, a lot of theft cases used to come. Everyone with proof of CCTV. Then what happened is, in fact, they never provided a copy to the accused person also. Mr. Basu would know because his junior came and challenged the entire process. I told him that if the police is not doing it, then you go and on an appeal because the police has to make sure that they provide digital evidence to the thing. And IO happened to be in the court at that time. So then I asked him that what is the thing. So he said that there are so many technical problems with the app itself. So, and in fact, there are so many technical problems that they face in providing digital evidence to the court, to the PP, to the thing, that they just, in fact, are hugely dependent on the 65-day certificate. So, if actually the question is going to be this A and B certificate will primarily be the main method by which the evidentiary value of electronic documents will hold for a long time. e-Sakshya app topic, it's like it's going through a lot of its own development.
Yeah, that's true. So we need to
All
just.
these questions not topic, that actually you have to answer the Ministry of whoever is home affairs. Not to serve.
So
e-Sakshya has focused on collection of evidence but not on the admissibility of the evidence.
sir, we know evidence law, there are always options for how you contradict, how you corroborate. Corroborate can always inspire more confidence. Contradictions decreases reliability. So that's always there.
Structure. This has been modified by the Home Department in 2025, April, that e-Sakshya, the IOs will have to shall record all videos and photos as evidence under section under this e-Sakshya mobile app. And then there is also a provision in this that says that the court can view and manage all Sakshya concerning to the jurisdiction in the CIS app, Sakshya portal on the ICGS. In fact, the court may also permit sharing of Sakshya with the accused and victim if represented by an advocate as per the provisions of 230 of the BNSS.
Yeah. So the notification is there. We will discuss these entire rules in the last class, but we have to see how these things will operate. Let's quickly finish this, otherwise we will not able to start Nyaya. Already we are document. We don't need to discuss anything. Last part we are least concerned. Let me quickly go to the. Okay, there are very interesting change. 165. It was earlier 162. 162, if you remember, there are lots of cases happen on 162. Because 162 has given enormous power to the court to call for any document. Many times issue arises in the old law, you have 123, 124, which says official communication, affair of the state. So official communication and affair of the state, both the sections says that the head of the department will decide. While 162 says that the court asking for a document, court has the power to call for any document. So if court is calling a document, which shall prevail? 162 will prevail or 123, 124 will prevail. Now this question was answered by Supreme Court in SP Gupta case, it's judge's transfer case. And in judge's transfer case, Supreme Court says that point of time that if a document is being called by the court has no other option, but the party has no other option but to bring that document to the court, raise objection before the court, and court will decide that objection. That was the mandate given by the SP Gupta case. So when you look at this provision of 165, it basically enumeration of SP Gupta case. So even if some party has the objection in respect of some document, if the court has asked for that document, party cannot refuse. Party has to bring that document to the court, and ultimately the final call will be taken by the court whether to allow this document or not, whether to make it part of court record or not in larger public interest. So SP Gupta case, same principle will apply. The last clause is a new thing, which was not there. This law says that the court cannot ask for document between communication between ministers and president. Let's see how the court reacts, because we know judicial review is a basic structure of the constitution, and many times for judicial review you might need this document. So let's see the court reactions later on. Okay, that's it in the evidence law. Last section I said beginning itself. It applied prospectively. So even civil cases may go for next 30 years. So what we expect that after 30 years we will carry evidence law also and the Saksya also. I hope tomorrow Supreme Court in some cases under 142 they will say that no, let me apply this retrospectively to all cases. That could be the blessings, otherwise two laws we have to carry together for the cases. Okay. Here with all of you, 15-20 minutes time. Till when we have time? Here in the Nyaya Sanhita. These are the chapters. Few things have been deleted. So it was not there. Unnatural offences, 377, 309, 310, 311, 124A, 497, 444, 446. These are all deleted from the IPC. But in the new law, those provisions are not there. Unnatural offence, I think, is unjustly deleted. We know the Supreme Court says that consensual relationship will not be criminalized, but then there can be non-consensual sexual relationship between the same sexes. So unless you have provision how to prosecute them, that was the only section under which you can prosecute a non-consensual relation. So late tomorrow sometime the court will make some changes or law will come. Last section I am just...
They can marry their wife, they can have sex.
Non-consensual is no more offense, non-consensual.
Non-consensual, we not say no offense, but like it will come not sexual offensive. So now 377 is the only section where we could brought in. Now it may go hurt, grievous hurt, those kinds of things, but not the sexual offenses. Yeah, assault, all those can go. They have added the definition of gender. They have used the word transgender. Now, yesterday the Parliament has made another amendment in the Transgender Act, and we see its impact. What happened? This is a good change. Property definition they have changed. Now both not tangible, intangible. Both properties become part of it. So they use every description, corporeal or incorporeal. New punishment, we all know community service as a punishment has been added. This was because of the case called Lodha Colony case, BMW case, where the Supreme Court directed for community service. So need arises for community service, but then community service has been introduced only in 6 offences in the Nyaya Sanhita. So these are the 6 sections where community service are being offences are there. No changes in general exception, private defense, no changes, abatement, no changes. 48 has been added in abatement. If someone's commit offense sitting abroad and abet in India, that is an offense. We know long ago in 50s, Mubarak Ali case, where someone sitting in Pakistan abated offense in India, and that point of time Supreme Court says that look, if sitting anywhere you commit crime, you can be prosecuted in India. So now we have there in the specific section has been added. Offense against women and children is a new chapter has been added in the Nyaya Sanhita. So all the offenses against women and children they club together in one chapter. Some sections are really progressive. So one is 69. So any marriage with deceitful means. It defined deceitful means. So someone belong to X religions, expresses as a Y religion, someone by hiding name, by promise of false marriage, promise of false job, promotion, etc. They can be prosecuted. Now why the need arises? The need arises because if you remember these cases, Dilip Singh, Naeem Ahmed, in all these cases, Supreme Court that point of time says It was all the case of false promise of marriage. So Supreme Court there says, if from beginning, if the intention was not marry, then will apply, rape will apply. But if from the beginning intention was to marry, but the person changes mind later on, then the section will not attract. So rape cases will not go. Now, how to prove them? It's not an easy task. So practically everyone will get rid of the cases. So now a separate class of cases 69 added, that anyone who do these kinds of develop sexual relationships with deceitful means, this is an offence under section 69.
What about him?
No remedy. Man has no modesty, so only for women. So there is no offence under the law. There is no changes under this law. This is very good section which they have added. Many times when the criminal commit offences, the criminals know JJ Act better than us. So many times they appoint young children for committing offences, whether it's a drug trafficking, they act as a carrier. What police used to do, they used to make the child also accused and adult also accused. Now we have an option that instead of making child as an accused, the people who employ the children for committing these offences, those people can be prosecuted. So very good provisions in that sense, which can be useful by the police. So we can only prosecute the offender who employ the child to commit offences. So in that sense, excellent provisions. Many sections become gender neutral. 354B now becomes 76. Earlier it was any man. Now says whoever. So whether it's a man or a woman, whosoever commit this offence, like disrobing. Now we have seen in Manipur riot last year, that we have seen the cases etc. where women are parading, and then behind that women, both male and female both are there. So it's not that only male commit these offences, female also commit these offences. So now it becomes gender neutral, both can commit this offence. Offence against human body, mob lynching is a new section, it was not there earlier. So 103 clause 2. Supreme Court has given a series of directions in Tehsin Poonawala case, asking the government to consider bringing new law on mob lynching. So we got a new law. Hit and run case, this is the only section which has not been implemented. So 106 clause 2. So only section in BNS which has not been implemented. Because sir, after when the law came, you have seen all transporter strike. 1062. So these are a compromise. So when government implemented, they say this section will not be implemented. 111 organized crime. It's a new section, it was not there earlier. When you look at the organized crime, there are many common offences included here, like trafficking, dacoity, ransom, prostitutions, human trafficking, smuggling. They can be considered as an organized crime. For organized crime, the requirement is, and that's important, the requirement is that in last 1 year or last 5 years they says, there must be at least one charge sheet against the accused person for similar offences. So the first case cannot be organized crime. It can only be when there is a say one black trafficking case is there under NDPS Act. The second case can be under organized crime. So not the first case. Organized crime, same applicable for the petty organized crime also. So we have organized crime under 11, 112 is petty organized crime.
Sir,
Yes, ma'am.
this organized crime, only the charge sheet is sufficient, or the accused has to be convicted?
Only charge sheet is sufficient, ma'am.
So that means the second time he commits the same
Yes,
offense?
second time they commit offences irrespective of conviction acquittal. In the first case, if the charge sheet is submitted, the second case can be booked as organized crime.
So that means we can apply this section in NDPS also? NDPS?
Yes, we can. We can. So along with the NDPS, we can add organized crime section. We can add. In second case. But remember, the first case should be ideally under the Nyaya Sanhita. Like after this act came into force. Terrorism, 130. Again, these sections, Remember, the language is exactly same what was there in UAPA. Now, why the need arises, I don't know. But now the terrorism become a general offence. Only safeguard is given is that if the dispute arises, SP will take a call whether will register FIR under the UAPA or will register under the terrorism under the Nyaya Sanhita. So it's a SP call to book either under these sections or under UAPA. Now UAPA comes with some safeguard. So there is a senior level officials like secretary level officer, joint secretary officer, permission sanctions required. Now here those such requirements are there. So even in the discretion of the SP, a case can be started under the Nyaya Sanhita, and then those safeguards are not available. Other chapter we don't have changes. Offence against state. Now this is new section added 152. We know 124A sedition has been deleted, but instead of seditions, what has been brought in, it is no way lesser than sedition. So it is in some context much wider than sedition. So you will find 152. So act endangering sovereignty, unity, integrity of India. And we have already seen so many journalists has been booked under 152. Some people publish something which government does not like, police book them under 152. So ideally it should be avoided, the very serious offences. It should be used only when the case is really such serious and not to political opponent, not to some adversaries or human rights defenders. But many times these provisions are used in some cases against the human rights defenders, against the adversaries, against the political opponent also. Offences relating to army, navy, no changes. Religion, no changes. Coin, no changes. Public tranquility, no changes. Public servant, no changes. Lawful authority, no changes. False evidence, etc., no changes. Public health safety, no changes. Religions, no changes. So most of the places we don't find much changes there. Mischief, criminal trespass. Document, we don't find changes. So those are the basically sections are there. Some changes are there. Quickly I will just finish. One is theft by snatching, 304. So by snatching, earlier the offence was theft, robbery, dacoity. So now in between we got one more category: theft, snatching, robbery, dacoity. So we say all these three categories, same categories. So now we have one between, we have a snatching. Miscellaneous, this new section added, it was not there earlier. Remember earlier there was 309, attempt to commit suicide. Now that has been deleted. Now new section added, if someone attempt to commit suicide to compel a public servant either to do something or not to do something, then it's an offence under 226. So the new concept has been added there, some with changes. That basically Nyaya Sanhita provision, we don't have much discuss in the Nyaya Sanhita. So any questions are there, we can discuss. Otherwise, my first boss used to say there's a thin line between hunger and anger. So we can go for lunch. So thank you. So tomorrow again we'll meet with BNSS and other law issues.